Hi, this is Joe from powerofattorneyform.com, and today we're going to go over the four main California power of attorney forms. Now, if you don't know what power of attorney is, it's basically just a legal document that allows you to make either financial or medical decision-making power on behalf of somebody else. Now, the first one that we're going to go to is the California Durable Power of Attorney form, all the way on the left side here. Now, what this allows you to do is to handle financial powers on behalf of somebody else in the state of California. And the form is, and what makes it so popular and so common, is that the form is valid if the principal becomes incapacitated or told by a licensed medical physician that they can no longer make decisions with a clear mind. Now, what that means is the person that's transferring their power to somebody else, if they, for instance, get one of these things that are plaguing our baby boomers these days, such as Alzheimer's or dementia, or any one of these things that can alter their thinking, this form stays valid. And the person can still act and pay their bills and do everything in their best interest for them, financially on their behalf, such as sign checks for them and do all those sorts of things while they're under that medical condition. So it's very important that the person that you choose is a trusted person, because they're going to have a lot of financial responsibility in their hands. Now, the next form that's second to durable, that almost is just as popular, but they both work hand in hand. And a lot of times when someone gets a durable, they'll get the medical power of attorney form. And it sounds exactly what it sounds like. It allows you to handle all medical decision making power on behalf of somebody else. Now, what that really means is you're almost acting as a caregiver to somebody else. Somebody else is just in a mental state where they just can't do it anymore. You are going to have to be the one making all the medical treatment decisions, facility decisions, and, if instructed, the right to end medical treatment if they turn into a vegetable and there's no point of return. But again, that has to be specifically requested in the power of attorney by the principal. And this form only kicks in when you have, or when the principal is not able to think anymore. So again, just to recap, durable, financial, medical, these both work hand in hand together. And I highly advise, if you get one, you typically want to get the other if you're in that situation. Now, the California General Power of Attorney form is just like the durable, except for the fact that if the principal becomes in a state of mind where they can't think for themselves, this form becomes void. So you're probably wondering, well, who would want this? But this form is very popular, giving power to your accountant to, say, make banking transactions for you, or giving power to an attorney to do some things for you. This is, as long as you're around and still kicking, you don't mind the person having this power. I mean, again, you should still make sure that the person's a trusted individual. And we actually see this quite common between business partners, where if someone's out of town or someone else is doing something, both partners will have general power of attorney with each other. And the last one, which is a pretty cool one, which is limited power of attorney, which allows you to give somebody else very specific financial powers, or just powers in general, where they can say you need a car picked up for you, or you need a withdrawal done, or you simply just need someone to sign all your mail at the office for you because you're never at the office. This form is perfect for that, because it only gives them power to do that and nothing else. And just like the general, If the principal should become incapacitated or not able to think for themselves, this form becomes void. Now, the only thing that you need to do to make any one of these forms legal, you just need to have both people sign in front of a notary. Now, if you don't know what a notary is or where to find one, don't worry, just go to any branch bank in the United States, and they always have a notary on staff, and you can easily they'll easily do the notarization of the POA for you. Now, if you have a bank account there, they'll usually do it for free. I know Bank of America, if you don't have an account, they'll charge anywhere from $8 to $10, but that's where you get it done. And you don't have to file it with any government agency. You just want to keep this form on you, and if you want to cancel it, we have a couple of cancellation forms on our homepage at powerattorneyform.com. But for the most part, that's it. These are the 4 main forms of power of attorney in California.